Confidentiality. Hey, we all know what it is, or do we? Well, that takes us to this week's case. Involves a real man in Florida, Patrick Snane. Now, Patrick was a principal at a preparatory school. He was 69 years of age, and he brought a claim for age discrimination. Won't go into the merits of the case, but long story short, he sued, he went forward, and before trial, he was able to reach a settlement with his employer, and he was promised a payment of $80,000. Well, as often happens on these kind of agreements, there was a confidentiality clause in the release, in the contract by which it was agreed he, Patrick, would give up his claim in exchange for $80,000. And in that agreement, in that contract, was a clause that provided the terms would be confidential. Patrick says, fine, thanks very much, we got this case settled, and he goes on about his life. Got home, and he and his wife told their younger daughter about the settlement. She goes to Facebook and posts on Facebook the fact that the settlement did take place, that they were going to get $80,000 coming into their family, and it was going to pay for her summer trip to Europe. Well, this went like wildfire through the school, and obviously got to the school authorities, and they called the prior principal's attorney. Said, you know what? You, at least your client, have reached the confidentiality agreement because it provided that you weren't going to tell anybody about what the nature of this agreement was. Well, this guy said, look, it was just oh, come on, it was just a posting to Facebook. Let's not get excited about that, just an innocent posting to Facebook. School said, no, it wasn't just a posting to Facebook. It went to a bunch of people. It's been recirculated to a whole bunch of other folks, and as a result, the confidentiality is blown, non-existent. On behalf of the plaintiff, the guy that brought the suit, his attorney says, I am going to move to have the terms of the agreement enforced, and that you guys need to pay $80,000. Well, he went to court. Court heard it, and the case actually found its way up to an appellate court. And the appellate court in Florida looked at it, and they said, well, you know what? The terms of this agreement, the terms of this contract are pretty straightforward, and it provided that the actual agreement and its provisions would be confidential. Well, here it is not confidential based upon the evidence we've received, because it has been posted to 1,500 people on Facebook, and from there it's gone to a whole bunch of other people. There is no longer any confidentiality, and therefore the agreement is unenforceable. In short, the plaintiff doesn't get the $80,000. Now, he, of course, can continue going forward with the case. He could take it to trial or various other things, but the agreement that he thought had sealed that case, took care of it forever and always, was unenforceable because of a breach of confidentiality. And what was the breach? Posting to Facebook. So what's the lesson of this case? It's very simple. When an agreement provides for confidentiality, that agreement can be broken by publicizing the agreement. It doesn't have to show up in the newspapers, it doesn't have to show up on radio or television. It has to, however, be shared with someone who is not a party to that agreement. That means if you post it to Facebook or on any other social media and it becomes known to other people, that's a breach of the confidentiality, and that can invalidate the agreement. Now, sometimes these agreements will have special clauses saying that for tax purposes you can reveal the information to an accountant or other people who need that information. But those are very narrow exceptions. In this instance, we saw how a confidentiality agreement works, and we saw, unfortunately, the downside of it. Okay, we bring you this case as you bring cases every week, so you understand how the law works. I'm David Allen.